All right. Hello, everyone. Thank you for joining the Center for Survivor Agency and Justice today. We're very excited to bring to you a webinar titled Federal Tax Advocacy for Survivors, What Attorneys Need to Know. We are thrilled to have one of our expert advisors, Jamie Andre, who is the director of a low-income taxpayer clinic out of Indiana Legal Services, going to give a really deep overview of federal tax advocacy needs, and we're very grateful to have you join us this afternoon or morning or wherever you're joining us from. Just a few notes before we begin. This webinar is being recorded, and we will provide you with all materials. By the end of this week, they should be posted on our website, and for those who registered or are joining us live today, you should also receive a direct email follow-up from us. And finally, just before we get going, to give you a quick overview of how this webinar platform works. In the lower right-hand side of the window that popped up, you'll see various icons that if you hover over, you'll get an idea of what they're for. You can view other attendees. You should open that call bubble, and that will allow you to chat, where I just sent a welcome message, and you can talk with us privately. You can talk with all participants. We encourage you to engage and use this function to ask questions, to chat with fellow attendees, to engage and tell us what your experiences are. In addition, if you need to zoom in and see the content more clearly, on the lower left-hand toolbar, you'll see a couple of different options that give you a different view of the PowerPoint slides here. I mentioned the chat, and if you need help, you should also see a little hand in the middle of your screen, and that will let me know that you have a question or you're having some difficulties, and I'll chat with you or try to troubleshoot with you as I'm able. So thank you again for joining us. Again, very excited to have Jamie Andre with us. My name is Sarah Lee. I'm CSAJ's project manager, and I'm about to hand it over to Erica Sussman, CSAJ's executive director, to introduce and place this training in the broader context to some of of this national project that we're doing here. But before that, I'd really like to hear from you and have you get familiar with this chat function. So introduce yourself. Tell us who you are, where you're from, and also tell us a little bit why you're here. What perspective are you approaching today's training from, or what do you hope to get out of our short but meaningful time together? And while this is coming in, I just want to give you a little heads up that we will be holding a couple of dedicated breaks throughout the training today. So I really encourage you that throughout Jamie's talk and all the content that she's going to review, that you continue to use the chat to ask questions, talk with each other, and share different experiences. And we'll help relay some of those during the discussion, but we really encourage you to engage in that way. I also want to give a hearty thanks to everyone for your responses in the registration survey. That's really helped us kind of guide a lot of this webinar today. So we hope that we'll be able to incorporate that a little bit throughout the training. So keep those questions and thoughts coming. We really rely on you for your insights and on-the-ground expertise and strategizing around some of these issues. So please use that function to engage with one another. And I see that there are a lot of folks joining us today from very different places, which is really fantastic. Texas, we've got Queens, we've got Pennsylvania, we've got legal services folks, we've got advocates and legal advocates, all sorts of folks. I am, just before I turn it over to Erica, seeing a couple of things. If you do get booted out or lose audio for some reason, at the very top of this window, you'll see a tab that says Event Info. You can always log out and then re-log in by clicking the web link from the emails you've been sent, and that tab should give you the audio and the call-in information that you need to reconnect. So with that, I'm going to turn it over to our Executive Director, Erica Sussman, to introduce CSAJ a little more fully and to introduce Jamie. So Erica, are you with us?
I am. Can you hear me all right?
Okay. Yes, loud and clear.
Great. Thanks, Sarah. So welcome, everybody. As Sarah said, we have gotten a really wonderful response to today's webinar, and so I'm thrilled to be joined by all of you with such diverse expertise and in such diverse locations, playing many, many different roles in organizations across the country. I am also really thankful to have our expert advisor, Jamie Andre, joining us and leading us in this webinar today. Jamie brings incredible expertise to this webinar and to all of CSAJ's work, so I'm feeling really privileged to have her with us. I'm going to talk really generally about CSAJ and then hop right into our program today. So the Center for Survivor Agency and Justice is a national organization that has been around since 2006. Our focus is at the intersection between intimate partner violence and poverty. And I just want to talk a little bit about that evolution. So when CSAJ was first born, it really came out of the recognition that we needed to make a paradigm shift to focus our efforts more on survivor-centered advocacy. In other words, what that philosophy looks like in practice, in legal practice, in other types of advocacy practice. And of course, a natural result of centering on survivors is a focus on economic security. We know from lots and lots of data and also from working with all of you over the course of many years now that access to material resources is a critical priority for many, if not most, survivors of domestic violence. Data shows that 99% of survivors articulate economic abuse as being part of the experience that they have. Oftentimes, the economic piece is even more present than the physical aspect of abuse. We also know that 2 times as many women who are living in poverty report that they've experienced economic, or rather that they've experienced domestic violence. And so the link between economics and poverty is of critical concern to CSAJ, and I know it is also to many of you across the country joining us today. So CSAJ really focuses on this from a multi-level perspective, and so that really goes to the mission of the Center for Survivor Agency and Justice. We're approaching this work both from the individual level, the organizational and community-wide level, as well as the systems change level, trying to integrate strategies that are focused on this intersection between poverty and intimate partner violence on all of those levels. I want to talk more specifically about the project that brings us here today, and that's the Consumer Rights for Domestic and Sexual Violence Survivors Initiative. This project has been around since 2007. We're a technical assistance project funded through the Office on Violence Against Women, and we have a whole slew of different expert advisors as well as important organizational partners that contribute to our work, and all of those partners are listed here, and Jamie Andre is one of our expert advisors. In terms of the what or the how of how we do our work, that takes us to the next slide, and that is just kind of giving you a very big picture overview. One of the things that we're currently working on is the creation of a guidebook, and specifically a consumer rights and economic civil legal advocacy guidebook that is going to be a comprehensive resource that provides really concrete guidance to lawyers and advocates on different areas of consumer and economic civil legal advocacy. Jamie is a contributor to that book, as well as many of you who are joining us on this call today, actually. I see that Laura Russell is joining us today, and she also is one of the main contributors to this book. And another piece of our work is advocacy briefs, and those are much smaller tools that are intended to help folks address either an emerging issue of advocacy or something that is more discrete. Example of that would be just a resource that we released just this past week on the National Consumer Assistance Plan, a settlement that was put into effect with the big 3 credit bureaus. And that piece is specifically focused on strategies for implementation around the needs of domestic violence survivors. We also do a whole bunch of different consumer practice webinars. We do them on a bi-monthly basis. So today's webinar would be an example of that. And we've listed here a number of different past recent webinars. All of them are accessible on our website. We also provide individualized technical assistance, so case-specific or community-specific technical assistance where we are able to pull together folks with expertise on a range of different issues to be able to help you think through some strategies that are going to be relevant to your context. And then lastly, we are, a very interesting piece of the Consumer Rights Project, I think, is our demonstration site work. So we have been engaged with the Texas Council on Family Violence, the Women's Resource Center out of Pennsylvania, the Indiana Legal Services, which is Jamie's project in Indiana, and the University of Denver Law School Civil Litigation Clinic. Each of these sites have been engaged in really in-depth assessment as well as implementation around creating some institutional changes to address the economic needs of survivors. If you want information about that or any of our other activities, you should absolutely reach out to us. So without further ado, I want to turn the program over to Jamie, who will provide us with some really rich information and thinking around the tax advocacy needs of domestic violence survivors.
Thank you, Erica. And thank you all for joining us today. It's a big group, and we have a lot of things to cover in a fairly short time. So I'm just going to talk briefly about what we will cover, and then we'll actually start to talk about those things in depth. We're going to talk about why you need to know something about tax, and then we'll go on to discuss filing status, the validity of tax returns, claiming the kids. I'm then going to give you some tips for representing survivors. We'll talk a little bit about audits, innocent spouse relief, and IRS's rules about disclosing tax information. And then I'm also going to give you some information about where survivors can get tax help for free. One caveat is that I'm not a tax preparer, and I'm also not a family law practitioner. My job is to help taxpayers solve their disputes with IRS. So I may not be able to answer certain technical questions about filing tax returns. Also, I don't practice in a community property state where the rules are very different. So I am probably not able to answer community property questions right off the top of my head. That said, let's get into the program. So what are our objectives today? Well, after today's webinar, you should be able to understand and explain some important tax concepts to survivors. You should be able to advocate on behalf of survivors in family court to maximize their tax benefits. And you should also know and be able to advise survivors where they can get free tax help. So why do you need to know about tax? Well, tax problems can cause or contribute to economic hardship. Your client may already be facing levies, which is IRS's word for garnishment, of her wages, bank accounts, or Social Security benefits. IRS may have filed tax liens which encumber marital real estate. And tax problems can be a sign of abuse. They may be related to or caused by the specific actions of the abuser. More reasons to know about tax. As I mentioned earlier, tax problems can contribute to economic hardship. Survivors need their refunds for a range of very important reasons. If a taxpayer's refunds are being taken to pay a spouse's debts, then the survivor will not have that money to meet her own needs. Survivors need their refunds. They can use them to pay and catch up on bills, create savings account, establish a residence, and get access to other basic items, including clothing or a car needed to obtain a job. Another reason why you need to know something about tax is that the client that you're representing may be required to file a tax return while the divorce is pending. And so, for example, if you're representing someone right now, it's filing season, and so a tax return is going to need to be filed sometime between now and April 15th. Divorce cases that involve children have major tax implications for the future, as there are multiple tax benefits related to kids. We're going to talk about some of those tax benefits. Those are things that you need to know as you help your client through the divorce process. And finally, decisions that get made either during divorce or post-divorce proceedings can impact whether your client can claim those tax benefits that are related to children. You are likely the primary person from whom a survivor is going to get help finding tax information. So if nothing else, that's a reason why you need to know about tax. Many survivors are confused about their tax rights and obligations. They may have had little or no experience dealing with tax. There's no obvious place to go for help. They may not have internet access and are unable to, for example, access the IRS website, which does provide some very useful information. Tax is one of these topics that has its own language. It's very intimidating. People think it has to do with math, and so they're particularly intimidated. And survivors are going to have tax questions that they may not be able to answer on their own. Taking control of one's financial situation, including the part involving tax, is empowering, and that's good for survivors. In addition, unaddressed tax problems get worse rather than better. When an individual owes tax, penalties and interest will add up, and the amount that they owe can really increase very, very quickly. There are also some bad taxpayers out there who will take advantage of vulnerable taxpayers. By providing tax information to your clients, you can help them understand the process of filing a tax return, and they can better protect themselves. Okay, so I mentioned that we're going to talk about tax benefits related to kids. I just want to run through very quickly what they are. We'll talk about some other things first, but I just want to have you have in mind what tax benefits there are that are related to kids, and then we'll talk about them in more detail later. So first of all, there is the dependent exemption, also called the dependency exemption. This benefit reduces the income that is subject to tax, and it's worth $4,000 per dependent for the 2015 tax year. Then there's the child tax credit. That reduces the amount of tax that is owed. So after, while the return is being completed, once income is determined, then the amount of tax is determined, and the child tax credit, if your client is eligible, will have their tax reduced by the child tax credit. The additional child tax credit not only reduces tax, but it is also refundable once tax is reduced to zero, which means even if your client doesn't owe any tax, they may be due a refund, an actual payment that is composed in part of the additional child tax credit. Then there's the earned income tax credit, and I'm assuming most of you are at least a little bit familiar with that. It's the only tax credit that has its own holiday. January 29th, 2016 was Earned Income Tax Credit Awareness Day. This is a critically important tax benefit that is available and is related to children. It reduces tax, and it is also refundable, and we will talk about it in more detail. The dependent care credit reduces tax for eligible taxpayers, and then finally there's the premium tax credit, which is related to the Affordable Care Act and the purchase of health insurance through the marketplace. It reduces tax, and it too is refundable, which means that once tax is reduced to zero, it can create a positive refund for your client. Okay, here's my warning. Tax law is complicated. Even very basic stuff like who can claim a child as a dependent, and we are not going to be able to cover everything that you need to know in an hour. So that's warning number one. Number two, as much as we would like it, there is rarely a quick and easy fix to a tax problem. And the IRS, which of course is the agency that you'll be working with, or that we are working with, moves at a glacial pace. It is really slow. And so there's nothing quick and easy about resolving tax. My main goal is to alert you to issues that your survivor client is going to face and give you some ideas about how you can address them, but there are a number of things for which you or your client may need to consult a tax practitioner. And there are free tax clinics, organizations such as mine and some of yours that represent low-income taxpayers. Finally, this isn't really a warning, but a very good source of tax information is the IRS website. The information there is written in a range, presented in a range of different ways. Some of it is very accessible to taxpayers. Some of it is going to be more geared towards attorneys and other tax practitioners. So, tax problems can be a sign of abuse. The more that you talk to your client, the more you will have a better understanding of whether their tax problems are in fact related to abuse. Some examples of tax problems that arise from abuse come from survivors being forced to sign a tax return, or perhaps not allowed to review a tax return before it is signed. Tax problems may indicate that your client was kept in the dark about household finances, including the spouse's income and expenses, and we'll talk more about that. Sometimes your client will have tax problems that have arisen because a spouse or former spouse has filed joint tax returns without your client's knowledge, or the spouse may have refused to file and prevented your client from actually filing tax returns, and so there are tax problems as a result of that. So there are a range of questions that you can ask to identify tax problems, and some of them are listed on this slide. I think it's in the nature of lawyers and maybe other professionals to kind of want to avoid talking about legal issues that they don't know anything about or don't know enough about. In my case, I have this, please don't ask me for advice about your kid's criminal case. I don't know anything about that. However, even if you know nothing about tax and are uncomfortable delving into it, you at least need to find out if your client has tax problems. As we discuss later, there is free help available for low-income taxpayers, and if you don't ask these questions, no one is going to ask your client these questions. In addition, if you're the lawyer handling the client's family law case, the tax solution is really part of that case, and there are places that you can go for help as well. One of the things that really is surprising and disappointing to me is that survivors still have a hard time finding their way to my clinic and to clinics like mine, even though we are well equipped to help them with their tax problems. If you identify that survivors have tax problems, are the people who can get them to people like me who can help them with their tax problems. So on this screen, I'm not going to go through them now, but on this screen you can see there are a range of questions that you can ask to help identify whether there are tax problems. Okay. So we're going to talk now about filing status and why it is important to survivors and their lawyers. Filing status is important for a range of reasons. For one thing, it impacts which child-related tax benefits are available to the tax filer. It also impacts what income is taxable. And I'm going to give you examples when we start to talk about the individual filing status. And it also impacts how much tax is owed and who owes it, and possibly how big a refund will be due to the filer. And as I mentioned earlier, a divorcing couple may be required to file while the divorce is pending. This is a big topic right now because, of course, it's tax filing season, and divorcing or just separated spouses, even if they're not divorcing, need to figure out what filing status to use for returns that need to be filed for tax year 2015. Okay, so filing status. There are 5 filing statuses, and here's what they are. Married filing jointly, married filing separately, head of household, single, which is not available if you were still legally married on December 31st of the year for which you are filing the return, meaning by the end of the day. So if you were married, still married on December 31st of the tax year for which you're filing the return, you cannot claim the filing status single. And then there is qualifying widow or widower with a dependent child, which is actually one that we're probably not going to talk much about today at all. Okay. If you learned nothing else today, and if your clients learn nothing else, married taxpayers do not have to file joint tax returns. Many survivors do not know that. Married taxpayers do not have to file joint tax returns, and we'll talk in a moment about the pros and cons of filing a joint tax returns. A taxpayer who is married can choose one of 3 different filing statuses. If the spouse concurs, they can file married filing jointly, or a married taxpayer can choose the filing status married filing separately, or a married taxpayer can choose head of household, but only if they meet the specific criteria to choose head of household. And we'll talk about that in a few minutes. Married filing jointly and married filing separately do not depend on living arrangements. And by that I mean married taxpayers who live apart can still file jointly. Married taxpayers who live together can still file separately. Head of household, however, does depend on living arrangements. And again, we will talk about that in a moment. And as I said a few minutes ago, marital status is determined as of December 31st of the tax year for which the return is being filed. Okay, so married filing jointly versus married filing separately. Well, there are some advantages to married filing jointly, which is why many spouses choose to file joint tax returns. There's a higher standard deduction. It reduces the income subject to tax. There are certain benefits that are available to taxpayers who file jointly that are not available when those same married taxpayers file using married filing separately. And a big one is the Earned Income Tax Credit. A couple that is eligible for the Earned Income Tax Credit, if they file jointly, neither one of them will be eligible for the Earned Income Tax Credit if they file married filing separately. And as we will talk about later, the Earned Income Tax Credit is a very significant tax benefit to people who are eligible. In addition, student loan interest and other deductions and credits related to education are not available to taxpayers who use married filing separately, and neither is the child and dependent care credit. So those are some of the disadvantages to married filing separately. In addition, if a taxpayer lived with his or her spouse at any point during the year, married filing jointly allows you to exclude more Social Security income from taxation. Now, if you have a single taxpayer and their only income is from Social Security, none of it's taxable, and they have to have quite a bit of income from other sources before any of it is taxable. So that's for single taxpayers. Taxpayers who file jointly, when one of them has Social Security, are kind of in the same situation. The Social Security is not taxable unless the couple together has income in excess of around $32,000, other income in excess of around $32,000, and then some of the Social Security income will begin to be taxable. If you use married filing separately and you have lived with your spouse for any part of the year in question, all of your Social Security income is going to be taxable. So that's really potentially a problem for people if they get a lot of Social Security. And then finally, usually another advantage to married filing jointly is that you usually pay less tax or do a bigger refund than if you use the other filing statuses. However, there are also risks to married filing jointly. The big one is joint and several liability. Spouses who file a joint tax return are each jointly and severally liable for all of the tax that is due on the return, either as the return is originally prepared by them or as it is adjusted by IRS. In addition, the spouses who file together are jointly and severally liable for any penalties or interest that result from tax due on the return. And this is true even if only one of the spouses had income, even if one of the spouses deliberately made a mistake or inadvertently made a mistake, such as concealing income or inflating deductions. If it is a joint return, both spouses are jointly and severally liable for the full amount, and IRS may pursue one or both spouses to collect tax that's owed on a joint return. So that's potentially a very big risk to married filing jointly that for some survivors is going to outweigh the advantages of filing together. The other thing that comes up with married filing jointly is that IRS may offset, which basically means take, some or all of the refund to pay towards one spouse's prior tax or one spouse's other debt. And we're going to talk about that in more detail a little bit down the road. That's something that can actually be fixed by filing a request for injured spouse relief, but I will talk more about that later. Okay, so the questions to consider before married filing jointly. With married filing separately, a taxpayer is only liable for her own tax debt when she files separately, and she will not have her refund taken to apply to debts that belong solely to her spouse. So that's an advantage to married filing separately. So one of the questions that a spouse might ask is whether there is some danger in filing jointly with her spouse. Can you change your mind? If you have filed a tax return married filing jointly, and after doing that you have a bad feeling and you want to switch to married filing separately, you only have until the due date of the return to amend and file separately. So you'll have a very short window of time to change from married filing jointly to married filing separately. Tax season this year opened around January 19th. The deadline for filing your tax return is April 15th. If you have filed, if you filed on day one, January 19th, you only have until April 15th to change your mind switch from married filing jointly to married filing separately. However, taxpayers who file separately have a much longer period of time, generally 3 years from the tax return's due date, to amend and file married filing jointly. So if you file a tax return, for 2015 now, you will have 3 years from April 15th, 2016 if that was a separate married filing separately return, to amend it and file jointly. There are other considerations too, which I'm not going to go into right now. So I have listed some questions that a survivor would want to consider before filing a joint return with her spouse, which anyone would want to consider. You know, a spouse who is secretive about financial information or who denies access to financial records and bank accounts, who conceals earnings, who is abusive. These are all factors that one should consider before going ahead and filing jointly. If a spouse is self-employed and doesn't keep good records, there may be real risks to filing jointly with that spouse. and spouses who control household financial decisions, or who have perhaps not filed tax return in the past, or who owe tax. These are all questions that you would want to consider before going ahead and filing jointly with the spouse. The other thing that I like to suggest people do when they're considering whether to file a joint return is to do the math. You know, what is the difference in terms of tax owed or refund that may be due if an individual files jointly with a spouse or files separately? For example, you might have a situation where a survivor has little or no income, or perhaps their income is SSI, that's not taxable. If the survivor files separately or not at all, she is not going to be due a refund. She might get a court order for half or even all of the spouse's refund, but may have to chase that down. Filing jointly with the spouse might produce a much larger refund. I have a case right now where a couple owes tax. The survivor's income is only Social Security. Neither spouse qualifies for head of household, and the survivor is trying to decide whether to file separately or to file jointly with her spouse. If they file separately, there is no earned income tax credit for either one of them. As I mentioned earlier, married filing separately, you can't claim the earned income tax credit. There would be no refund from the survivor's return, and only a minimal, if any, refund from the abuser's return. If they file together, there will be a $5,000 plus earned income tax credit because they have several children, and that will be enough to pay off the joint tax debt from the past and have some refund left over, which could then be divided by the court. So these kind of calculations are very useful to determining whether or not one would want to file married filing jointly. Okay, this slide actually mentions some public comments that CSAJ submitted to the Department of Education on student loan repayment. And the gist of the comments were that domestic violence survivors should be able to file married filing separately for their own financial and other safety and still be able to qualify for the new income-based student loan repayment plan. And that was a good effort and successful. Okay.
And I just want to hype up on that, Jamie, if I could.
Yeah.
That was a really exciting effort, I think. I think a really nice example of some good systems change work that we were able to participate in with Jamie's leadership and in coalition with many programs across the country that were encountering some tax-related issues and anticipating what the student loan repayment regulations might present for survivors. So drawing together those comments and really trying to illustrate survivors' experiences around tax was very exciting. And then, of course, we had the opportunity to present it at the Department of Education, and we're waiting to see what happens. But just a great example of some good systems change work that all of you have helped us in pulling together, and we hope that you'll keep us aware of some of these issues in the future, too, so that we can push forward on that.
Thank you, Erica. It was very exciting. It had to be done pretty quickly, too, which made it even more exciting.
Yeah.
Okay. On to head of household. So the benefits from head of household, and I mentioned earlier, married filing jointly and married filing separately, they don't depend on living arrangements. Married couple living together can file separately. A separated couple can file jointly. This is not true with head of household. To qualify to file as head of household, you either have to be unmarried or considered unmarried by IRS. And what that means is that the taxpayer claiming head of household has to have lived apart from her spouse for the last 6 months of the tax year. And so if you have a survivor who separated from her spouse in October of 2015, that survivor is not going to be able to claim head of household, okay? In order to claim head of household, in addition to either being unmarried or being considered unmarried, one also has to prove that you provided the principal place of abode for dependents, for at least one dependent, that you provided more than half the annual support for your household, and there's a worksheet that's used, and that a qualifying person lived with the taxpayer for more than half the year. It's a very complicated test, and we don't have time to discuss it, but for details about that, I encourage you to look at IRS Publication 501. All of the IRS publications are on the IRS website. Okay, so the benefits to head of household, because it's not a joint return, you don't have to worry about joint and several liability that comes from filing jointly. It's a higher standard deduction than married filing separately, and the filer can claim the earned income tax credit. This is sort of just a little warning. We're going to talk about audits later. IRS will audit returns to ensure, not all returns, but will sometimes audit a return to ensure that a taxpayer qualifies for head of household. And one of the things that's going to be an issue is whether the taxpayer, if she is still married, lived apart from her spouse for the last 6 months of the year. Okay. This slide just gives you some references to where you can find more information about head of household. Okay.
So before Jamie delves into this slide, I just want to mention that we're going to be opening up our conversation for some audience participation in a little bit. In addition to asking Jamie some questions about the materials that she has shared so far, we're also going to be thinking together about some of the common challenges that folks face in providing representation and advocacy to survivors around these tax-related issues. So would absolutely love to hear from all of you around your own experiences so that we can start to brainstorm solutions that address some of those challenges. So that's going to happen in about 5 minutes or so.
Okay. Before that happens, we're going to talk about whether a tax return is a valid return. This question typically comes up when a survivor finds out that she owes tax arising from a joint return and she didn't know that a joint return was filed. Or it comes up when the survivor was aware that a joint return was filed but did not want to participate and signed the return under duress. A return that is signed under duress is not a valid tax return, and there's a couple of cases cited there, and they talk about what duress is. Basically, if a survivor has been pressured or forced by violence or a range of different types of threats to sign a return, it is not a valid return. Similarly, if a signature has been forged, it is not a valid return. Now, some of you may be saying, who signs tax returns? Well, in fact, paper returns are still signed and filed on paper. And in fact, IRS won't process a paper return if it is not signed. So there are returns out there, and we're going to talk more about paper returns a little bit later, where comparing the signatures might be one way to determine if there's been, or to establish that there's been a forgery. Obviously, returns that are e-filed usually don't have a signature. They use a PIN number. The burden is on the survivor or on the taxpayer who's claiming forgery to prove that and to prove that there was no intent to file a joint return. Even in cases where a survivor did not participate in the filing of a return and it's essentially a forged return, IRS will determine if there's tacit consent, and I'm going to talk about that in a moment. But I just want to give you one example of a forgery that we were able to establish. I was representing a client who basically left her abusive husband and moved 3 or 4 states away on the day that she received her back Social Security disability award and moved in with her sister. The client and her husband had filed joint returns in the past, and the husband went ahead and filed a joint return without her knowledge or consent. It was obvious that he hadn't spoken to her about the joint return because he didn't include her Social Security income, part of which was taxable based on their total income. He did not know that she had it. IRS then audited the return because of the omitted income and assessed tax, penalties, and interest without the survivor's knowledge. When she finally learned of it and came to me, we alleged that it was not a valid return, that it was essentially a forgery, although it had been filed electronically. We were ultimately successful in our argument, and so as a result, she was not responsible for the tax. But I did at one point have a very bizarre conversation with someone at IRS who I sort of posed it as an identity theft case, and the IRS customer service representative said, well, it can't be identity theft if it was your identity was used by someone you know, and that's clearly not the case. I want to talk a little bit about tacit consent to filing a joint return. IRS takes the position that even if a taxpayer did not participate in the filing of the joint return, they may have tacitly consented. So here's an example of that. I'm married. I'm the tax attorney, so every year I prepare our joint tax return, which is filed electronically. Does my husband look at it? It's his return too, but does he know what's in it? The only reason that he knows that I'm preparing our joint tax return is because I am complaining about it during the entire time very loudly while I'm doing it. If I screw up the return and he wants to complain after the fact that it's not a valid return because he didn't participate, he didn't sign it, or, give me his PIN number, IRS is not going to go for this. There's tacit consent. We have a history of filing jointly. He gave me his tax information. He had no reason to refuse the return, no indication of coercion. I have indicated on this slide some of the indications of coercion, what IRS might hear from a taxpayer that would lead IRS to believe that there was not tacit consent, but that in fact there had been coercion to enter into a joint return. In the case of the client that I had described to you before, we raised abuse, the fact that she had fled, that she didn't tell her husband about her Social Security, and IRS agreed there was no tacit consent despite a prior history of filing jointly. And we also filed a individual return for this client, so that she could establish that as more indication that she had not intended to file a joint return with her spouse. Okay, so what do you do if a return is not valid? Well, a survivor has the right to file her own return and should do so. If she files a return and IRS processes it, does not process it because a return has already been filed by the same taxpayer, or it considers a return to have been filed, IRS does have its own internal assistance unit, the IRS Taxpayer Advocate Service, that can work with the taxpayer to help get her return processed. IRS has identity theft procedures that can be used to remove from a taxpayer's account a tax debt that arises from an invalid return. The taxpayer would have to file an ID theft affidavit using IRS Form 14039. And actually, I think that this can be a very effective way to deal with a return that is not valid. In addition, we're going to talk later on about innocent spouse cases. IRS's innocent spouse unit, which is located in Cincinnati, will work to resolve cases that involve invalid or returns that are alleged to be invalid because of duress and forged signature issues. So there's actually a procedure for getting it done. And some of the tax practitioners I know treat these as identity theft cases. Some don't. I like to because I think that has been pretty effective in the past. Okay. Now's our time for questions.
Yes, thanks, Jeannie. So I think maybe what we could do is start off by folks sharing some of the challenges. I know that a number of you in your registration had jotted in a couple of common challenges that you face, either that you face as an attorney or that your clients are facing in their experiences. So if you want to chat some of that over to us, perhaps we can start thinking a little bit about that together. Okay, one person asks, if the survivor does not have a dependent or a child, from when and in what situations can the survivor file as single, especially when the divorce is finalized at the very end of the year?
Okay. And I don't know if I can see that one. So did it say that the survivor did have a child or did not? Yeah, read it one more time.
If the survivor does not have a dependent, yeah, no child.
No child, okay.
Mm-hmm.
Well, end of the year really has to be more specific in order to know if the taxpayer can file a single. If the divorce occurred on or before December was final, on or before December 31st of the tax year, so in this case it would be 2015, then the taxpayer can file a single. But if on December 31st the taxpayer was still married, and it's a state law issue of whether you are married, where you are in the divorce proceeding, then the taxpayer does not have the ability to file a single if they were still married on December 31st. But if the divorce is finalized on December 31st and they are no longer married, then they can file as single. Taxpayers,
Thank you.
And I guess I should say one other thing. Taxpayers who have children can file as single and claim children as well. So that filing single doesn't prevent you from claiming dependents.
That's helpful. Thank you. So here's another interesting question. I'm curious about Jamie's response, and I'm also curious about whether other folks on this call may have some strategies to offer as well. So the question is, could you address best practices in working with a tax preparer in order to ensure safety during a joint filing process? And then another concern that they raise is so that the refund is deposited and so that it can later be divided. So it sounds like trying to address some of the safety consequences of joint filing, as well as trying to ensure that the survivor has access to the refund.
Well, I have a couple of suggestions. The first thing I want to say about the splitting of the refund, one of the things that people need to keep in mind is that when you file a tax return, jointly, singly, regardless of filing status, the filers can designate up to 3 accounts into which the refund can be split, and can also designate the proportion of the refund. You know, 50% goes into this account, 25 into this one, 25 into that one. And there's a form, it's IRS Form 8888, that you use to designate what accounts you want your refund to go into and in what proportion. So that's one thing that can be done to split a refund. You know, there's a variety of strategies for protecting the safety of a survivor and working with a tax preparer. You know, the tax preparer has to be cooperative and understand the circumstances. But for instance, the tax preparer can meet with each spouse individually and obtain, you know, the tax preparer is going to need information returns and other documents and items from the taxpayers, and they can be delivered separately. They can be delivered to the spouse's attorneys if the spouses have attorneys, and then they could be sent to the taxpayer preparer. The tax preparer can meet with the spouses by conference call instead of in person. So there are a couple of things like that that can be done. Some family law practitioners want to have the refund directed into one or I suppose both of the attorneys, split into both of the attorneys' client trust accounts, and then it makes for easier, safer, and more reliable division. I mean, those are a couple of the things that you could do.
I'm really glad that Megan raised this question, and I think that one of the things that it underscores is some of what we've seen in our demonstration site work around the real importance of building partnerships with, in this case, it would be with folks who are preparing taxes between domestic violence advocacy agencies and tax preparer experts, so that those who are engaged in doing this work are aware of the physical. I mean, Jamie was just speaking to some of the really concrete and helpful ways of accessing the economic piece, and I think that domestic violence advocates and the organizations that they work for are uniquely positioned to be able to think through some of the physical, potential physical consequences of engaging in this process. And so, you know, I think some of the work that creates for us is thinking ahead of time, not just with regard to a particular client, but really trying to create some plans for developing relationships that are going to serve our clients as the issues arise.
That is a great point.
And Jamie, we have one other question coming up here as well in the question box that says, should an undocumented spouse have any concern that the documented spouse or father of children declare their children for tax purposes? So we're talking about undocumented survivors with children married to a documented spouse.
Okay. Well, I mean, there are potentially all different kinds of concerns, and I guess I want to make one statement about undocumented individuals. Undocumented, and this isn't directly responsive to the question, I know, but it's a good time to bring it up, I think. Undocumented workers are required to file tax returns and pay taxes or maybe do refunds. And someone who does not qualify to get a Social Security number can get an ITIN, which is an individual taxpayer identification number, which will enable them to file tax returns and for IRS to process those returns. And so it's a real pain in the neck to get an ITIN. And I think maybe on a later slide I describe it a little bit, and I could certainly answer questions about it. But that is something that if you're working with undocumented survivors, you need to be aware that they can and should do. Question about the concern about whether an undocumented survivor should be concerned about having the spouse claim children. You know, I'd say I don't know if the question means with respect to immigration issues or future immigration concerns. You know, the claiming of a child as a dependent doesn't necessarily cast any aspersions or make any recommendations about, you know, who's a better parent or who's, you know, more suitable for adjustment of status. I mean, I'm not 100% sure I understand what the question is, but there may be financial concerns. You know, it's tough to answer that question, really.
Well, maybe if the asker of that question wants to chat us a little bit more detail, Jamie can take a look at that for the next go-around when we have a break. So I'm going to suggest right now that we hold off a little bit and delve right back into the materials, and then we'll have another opportunity to open it up further down the road.
Yeah.
Okay.
There's some good questions on audits and things, so we'll make sure to hold those for the next break.
Okay.
Thank you.
All right. Claiming the kids. The rules are complicated. The terms don't mean what they ought to mean based upon just common language, and the slides that you're going to see really barely touch the surface, and I'm sorry for that. But I'm going to talk about the issues that are most common when spouses divorce relating to claiming the kids, and these relate to children that the spouses have in common. Okay, so the dependent exemption. Exemptions reduce your taxable income. You can claim an exemption for yourself, an exemption for your spouse if you're filing together, and $4,000 exemption for each person who qualifies as a dependent. And there's a qualifying child, and there's also a qualifying relative, which we're not going to talk about today, but doesn't even necessarily have to be a relative. The IRS publication that I mentioned earlier, 501, gives you great detailed information about the dependent exemption. Basically, to be claimed as a qualifying child for the dependent exemption, the individual has to meet 5 tests to be claimed. They've got to meet a relationship test. They've got to meet an age test. They have to live with the taxpayer for more than half the year, although it doesn't have to be consecutive months. It can be the first 2 months of the year, and then there's a gap, and then the next 2 months of the year, and then there's a gap, and then the last 3 months of the year. But that's a residence requirement. There is a support requirement, but it's that the qualifying child must not have provided more than half of his own support. If the qualifying child provided more than half of his own support, he can't be claimed as a dependent. And then you can claim as a dependent a married qualifying child who has even filed his own joint tax return, but only if filing the joint tax return was simply to claim a refund. Okay, so the important part, I think, for us is that when parents are divorced or separated, it is generally the custodial parent who claims the child as a dependent. There are some exceptions, and we'll get to that in a moment. But there's one weird thing that you need to keep in mind, which is that IRS has its own definition of who the custodial parent is. IRS defines the custodial parent as the parent with whom the child has spent the most number of nights during the year. If the child has lived an equal number of nights or spent an equal number of nights with both parents, then the custodial parent is the one who has the highest adjusted gross income. If IRS audits a return and the question is whether the child has spent the most number of nights with that parent, the parent may need to be able to document where the child was, and that can be very difficult. And another important thing to consider is that while the family court can decide in a divorce decree or subsequent decree which parent gets the dependent exemption, IRS is not necessarily bound by the court's decision. It goes by its own rules about who the custodial parent is. IRS actually has access to a database that the rest of us don't have, and it has court orders in it, and it has paternity orders in it, and it has all kinds of other records. And although IRS is seriously underfunded, it can, in theory, audit a tax return when what's reported on the return conflicts with what's in the database. You know, as what it means in practice really depends. For many clients that I see, mom and dad are separated, they may never have married, they have a child, there's no court order stating who has custody, setting out parenting time or visitation schedule or anything like that. Well, who gets to claim that child? According to IRS, the parent with whom the child spent the most number of nights. So that kind of shows you how you might have a custodial parent even if you don't have a custody order. Okay, if a parent claims a child, that parent is now responsible for making sure that the child has minimum essential coverage essential coverage under the Affordable Care Act. If the parent who's claiming the child as the dependent doesn't have minimum essential health coverage for the child and the child is not exempt, then that parent is going to incur the individual shared responsibility payment, which is a penalty that is reflected on the tax return. So that's one of the responsibilities that now comes with claiming the dependent exemption. However, if the parent is claiming the child as a dependent, then the parent can include that child in the household for calculating whether the parent is eligible for the premium tax credit to help pay for marketplace coverage and how much they actually have to pay. And just as a reminder, taxpayers who in 2015 got the advanced premium tax credit have to reconcile eligibility for the amount that they received on their 2015 tax return. We are seeing lots of cases from 2014 where people did not reconcile the advanced premium tax credit, and now they're getting notices sending them from IRS, sending them to us to get that done. Okay, so what is the exception to the custodial parent claiming the exemption? Well, a custodial parent can release the exemption to the non-custodial parent. If the custodial parent gives the non-custodial parent the exemption, the non-custodial parent also gets to claim the child tax credit, any educational credits for the child, and as I said earlier, the child goes into the non-custodial parent's household for the ACA. However, the custodial parent can never give away the earned income tax credit. The non-custodial parent cannot claim the earned income tax credit. Even if the custodial parent gives up the dependent exemption, the custodial parent, if they are otherwise eligible, can still claim the earned income tax credit and actually the dependent care credit for that particular qualifying child, even if the dependent exemption has been given to the non-custodial parent. If the custodial parent is going to release the exemption to the non-custodial parent, there's a form, it's Form 8332, that the non-custodial parent has to have the custodial parent sign, and then the non-custodial parent has to attach it to the tax return, at least for divorces that took place after 2008. I'm a little concerned that we are running out of time, so I am not going to talk about what's on the next slide, which has to do with divorces that took place before 2009, because there are slightly different rules for releasing the exemption, and you can read those. A custodial parent who grants an exemption, say for all future even years, can actually revoke that exemption using Form 8332, and then the custodial parent would attach that to her tax return. Okay, I want to talk about some tips for representing survivors when it comes to the dependent exemption. The first thing you want to do is try to avoid custody orders that split physical custody 50-50. If the parents follow that, it means that neither parent has the child more than half the year, and it will disqualify both parents from receiving the earned income tax credit, which we will talk about in greater detail shortly. I encourage my clients, and I encourage you to encourage your clients, to keep track of the nights that the children are with her. I recommend doing it on a readable calendar that could also be photocopied, just noting which nights the kids are with her. This can prove useful if IRS audits a return. And if your client is the custodial parent as defined by IRS and is going to be claiming the children and claiming the earned income tax credit, encourage your client to make sure that documents such as leases and records like school records and welfare department records and medical office records reflect that their children are living with her. I can't tell you the number of audits we've been involved with where the client assures me that there's all kinds of documents showing that the children are living with her, and in fact, school records were wrong. The child is living with my client, but the school has a different person's address so that the child can go to a better school. The client's child lives with her but is receiving food stamps in somebody else's assistance unit, and it's turns out it can be very hard to get records when IRS audits a tax return that document that the child lives with your client. When the records are wrong because they were never changed or they were deliberately inaccurate, it's impossible to document reality, and it can cost your client thousands and thousands of dollars for the earned income tax credit. I just want to say a few words about the child tax credit. It goes with the dependent exemption, so it's claimed by the custodial parent unless she releases the dependent exemption to the non-custodial parent. It's worth money to survivors who can claim children as dependents. The child tax credit is, as well as the additional child tax credit, so that's why I have included a slide so that you will know about it. The earned income tax credit can be worth a lot of money, and it comes in the form of a refund to a taxpayer who qualifies. It accounts for some of the very large refunds that low to moderate households receive. Even when their withholding is not that high, it's basically it's the largest cash anti-poverty program in the United States for working people with children, and it's a refundable tax credit, which means first it reduces the amount of tax, if any, that's owed, and then the balance of the earned income credit can be refunded to the taxpayer. For the 2015 tax returns that are being filed now, the maximum earned income credit is over $6,000 for a taxpayer who claims 3 qualifying children. It's about $3,300 for a taxpayer claiming 1 qualifying child. So this is really a big sum of money, and it is a benefit that you want to make sure that your client is able to have. You have to file a tax return to get it, and as I said before, unlike the dependent exemption, the earned income tax credit cannot be transferred to the non-custodial parent. Only the person who qualifies for it can get it, and the parent who qualifies for it can claim it even if the other parent is getting the dependent exemption for that year. It's not available when the taxpayer files married filing separately. It is also not available to taxpayers who are married filing jointly if one of the spouses has an ITIN. Now, if you qualify for head of household because you've lived apart from your spouse for at least the last 6 months of the year and the spouse has an ITIN, that doesn't disqualify you. It's only when you are married filing jointly with a spouse who has an ITIN that the earned income tax credit is not available. And you can get the earned income tax credit if you're filing singly. You have to have earned income. You have to have a Social Security number, and any qualifying child you claim has to have a Social Security number. The child has to satisfy a range of different tests. They have to be related, and related means related by blood or marriage or adoption, or a child would be considered related if placed in the care of the taxpayer by a court or a placement agency as a foster child. In addition to the relationship test, there's an age test. There is also a residence test. A child is not a qualifying child for the earned income tax credit unless the child has lived with the taxpayer for more than 6 months of the year. And this is something that, again, may come up in an audit. Taxpayer also has to have investment income below $3,400. In the 9 or 10 years I've been working in a low-income taxpayer clinic, I've only seen one person who had investment income that made them ineligible. There are tiebreaker rules if both parents claim the children for the dependent exemption and the earned income tax credit. Typically, if the the earned income tax credit goes to the parent with whom the child resided the longest during the tax year. If it's equal, then it goes to the parent with the higher adjusted gross income. Earned income tax credit audits. Believe it or not, about a third of all IRS audits are of taxpayers who claim the earned income tax credit. IRS audits these returns because the error rate for the earned income tax credit is very high, the rules are complicated, the EITC is subject to abuse. The audits usually involve proving that the taxpayer has the correct relationship to the children claimed as qualifying children, proving that children lived with the taxpayer for more than 6 months of the year, and proving the taxpayer had cash income that's reported on the return, because sometimes reporting more income results in a larger earned income tax credit. And IRS requires documentation, which is often, unfortunately, very hard for taxpayers in general to get and survivors in particular to get, particularly those who are living in shelters, who are, you know, on the run, who have lost possessions. And it really requires quite a bit of creativity to come up with the documents that they need. You know, I encourage people to keep a contemporaneous calendar, noting when they have the children. If a taxpayer signs the lease and the children are with her, she should put the kids' names on the lease, correct institutional records, and keep copies of welfare agency notices that list members of the household. And make sure that you know that your client knows how to get legal help. Okay, I want to talk about the race to file to claim the kids. You know, when one parent files claiming the children that the other parent intended to claim, filing first prevents the second taxpayer from filing electronically, but it does not prevent the second parent from filing a return. So if you are representing a survivor and the survivor's spouse has filed and claimed the children when that was not what was supposed to happen, the survivor can and should file a paper return by mail, keep proof of mailing. It takes around 6 weeks to process a paper return, so it's slow. But that is really a necessary step to solve the problem of the other parent having, you know, rushed in and claimed kids that he wasn't entitled to claim. Now, so IRS is going to get both of these tax returns. What are they going to do with them? Well, IRS it may audit both of them. It may process one and not the other. You may need, your taxpayer may need to get help to ensure that hers is processed. But IRS is capable of figuring this out if your survivor has good tax assistance and has filed that return. Even if IRS has issued a refund to the wrong parent, it can still issue another refund to the correct parent and then try to collect from the parent who got a refund that that parent wasn't entitled to receive. I also tell my clients, if the other parent or even a non-parent, some other person is threatening to file and claim your kids, file your return anyway. Get into the tax preparer or go online and do it yourself and file that return electronically as soon as possible. Many times there is a threat that someone is going to claim your children, but it's either not carried out or it takes a while for them to carry it out, and in that meantime, the survivor can file and claim the kids on her own. Okay, So this slide just has a couple of reminders, things that we've covered already, and I'm not going to repeat them because of time constraints. I don't know if we have time for questions, do we?
So I think that what we might do, since we are running a little bit short on time, we're going to go until 2:45 Eastern Time.
Great.
And let's skip this question and answer right now. I want you all to know that we see your questions, and what we'll do is we'll pull together a little Q&A, frequently asked question type sheet, and share it with you all after today's call so that you don't have to worry. All of your questions will be addressed after today's call.
The other thing is that my contact information is contained at the end of the PowerPoint, and so feel free to email me your questions. Now, if everybody emails me their questions, it's going to take me a while to get back to them, but, you know, I can, you know, in the future, if people have questions that come up, I'm more than happy to try to, you know, help you answer your questions. So,
great. And
okay.
This is Sarah. Really quick. Sorry, Jamie. One other thing is,
okay.
If you do have to leave at any point, anyone, do make sure that you complete the survey that will pop up. That's a great place to put any remaining questions or things that we weren't able to answer. So we encourage you to fill that out anyway, but this in particular is a good opportunity for us to kind of aggregate some of those frequently asked questions so we can get those responses to everyone. So just a note on that. Go ahead, Jamie, sorry.
Okay, I want to talk about some tips I have for representing survivors. You need to talk to your clients about tax returns. The one that will be due next, any past due returns, claiming the children, has the spouse been able to, or has your client been able to? A survivor can file her own return even if she's got no filing obligation and no income. She can file what's called the zero return to protect herself from her spouse filing and using her name and Social Security number without her knowledge and consent. If she files her return first, it will prevent a fraudulent return using her name and ID number from being electronically filed after she files. In addition, if a survivor is aware that her spouse is using her Social Security number and other ID without her consent, a police report can be filed, and an ID theft report should be filed with IRS using the IRS Form 14039. And that's got instructions. The other thing that I recommend people do is make sure that IRS has a correct mailing address for your client, even if it's going to be temporarily to your office, because otherwise, if joint returns have been filed or a spouse attempts to file a fraudulent return, all of the IRS notices are going to go to the address on that return. There is an IRS form available on the website, 8822. That is the form that should be used for notifying IRS of your client's address, and that way she will make sure that she gets all of the notices. Now, I had mentioned injured spouse relief earlier. It's a useful tool for many married taxpayers, even those who are in perfectly amicable marriages, as well as being a useful tool for survivors. When a married couple files a joint return showing a refund is due, the refund may be taken to pay certain debts that are owed by one spouse or by both spouses, and it typically applies to student loan debt or child support, or if one spouse was overpaid unemployment benefits or tax debts. If the refund is being taken to pay a joint debt of the spouses, such as for a prior year's tax debt, then injured spouse relief is not applicable. But if the refund is being taken to pay towards one of the spouse's individual debt, the other spouse can request injured spouse relief. And what the injured spouse will get is her share of the refund based on her income and withholding and a division of the exemptions and the credits. You can request injured spouse relief using IRS Form 8379. It can be filled out and attached to the tax return that they're filing in situations where the spouse knows that the full refund is otherwise going to be taken to pay to the other spouse's separate debt, or it can be filed by itself after the tax return is filed, because sometimes people don't know that their spouses have debts that are going to cause a refund to be taken. And a spouse can go back 3 years and request injured spouse relief for the prior 3 years. It's only useful, as I say, where the tax return shows a refund, and it's only useful when the debt is not a joint debt of the couple. It's only useful if it's an individual debt of one spouse. Then the other spouse can claim injured spouse relief. Okay, I talked about a little bit about splitting the tax refund when I answered the questions. There is also the opportunity to split a joint tax debt. You can get information about all of the outstanding tax debt, at least that is joint tax debt or your client's tax debt, from IRS. I'll talk about that in a moment. Unfortunately, IRS is not bound by a divorce decree stating who is responsible for paying. IRS can collect from either or both, but in fact, there may be some very good reasons. There are some very good reasons to include in a divorce decree that, for example, the abuser is responsible for all of the joint tax debts of the party. Because even though IRS isn't bound by that, besides the fact that it may enable the survivor to go back and enforce that in family court, it may help persuade IRS. It might be a factor IRS will consider in granting innocent spouse relief. Let's see. I am going to skip these next couple of slides, although I can come back to them because I want to talk about innocent spouse relief in our remaining couple of minutes, as I know people are very interested and asked about that. And we could easily do a webinar devoted exclusively to innocent spouse relief. It's complicated, but at least I'm going to explain what it is. So as we discussed, when a married couple files a joint return, they're both legally liable for paying the full amount of any tax due plus the full amount of penalties and interest. It doesn't matter if only one spouse has income. It doesn't matter if one spouse made deliberate errors like concealing income or inflating deductions. And because they are both liable for the full amount, IRS can collect from either one or both up to the total amount owed. Unfortunately, what I have observed is that IRS often collects from survivors because they are easier targets. While the abuser might be self-employed or working for cash under the table or have no income, the survivor may have regular wages or Social Security benefits that can be levied or a bank account that can be levied, and is just more often the source of any funds that are paid on the debt. IRS doesn't know a taxpayer is a survivor, by the way, unless somebody tells IRS. So what is innocent spouse relief? It is a decision by IRS that one spouse, the requesting spouse, does not owe part or maybe even any of the tax penalties and interest arising from a joint return. It doesn't apply in cases where a return has been signed under duress or as a forgery. There are different procedures for that. We kind of talked about that a little bit. It only applies to a valid joint return. So there are a range of factors that IRS considers and takes into account when determining whether to grant innocent spouse relief. And relief is sought using a very long, complicated form called IRS Form 8857, which I'll talk about a little bit. But Some of the factors that IRS takes into account is the marital status of the parties at the time the relief is requested, how the tax debt arose. Was it because of a mistake on the tax return, or was the return correct, but did one spouse fail to pay the amount shown on the return, the tax due after promising to do so? If there's a mistake in an item on the return, such as omitted income or an overstated deduction, whose item is it? Whose income is it? If it was not the requesting spouse's item, did she have reason to know that it even existed, that the other spouse had this income that was left out, or that it wasn't correct? IRS will consider the requesting spouse's level of education, health problems, involvement in the spouse's business, involvement in preparation of the return, whether the spouse had the opportunity, the requesting spouse had the opportunity to review the return, and will also consider both economic hardship to the requesting spouse and abuse. And IRS defines abuse very broadly. It includes physical, and it's not limited to, but it includes physical harm or threats to the survivor or her children or other family members. It includes sexual abuse. It includes steps that might make a survivor fear raising disagreement with an abuser. It includes criticism, insults, withholding money for food or other basic needs, control of financial decision-making, other kinds of control. Abuse can include isolating the survivor or stalking or drug or alcohol abuse. Just a range of things. IRS is very open to what the survivor's experience has been in determining whether there's abuse. And while you don't have to demonstrate abuse to get innocent spouse relief, it is a factor that weighs extremely heavily with IRS. The form, the most recent version of it came out in January of 2014. It is much better than the prior version as far as the quality of information that IRS is trying to collect. It is a lot of work. It is stressful for the survivor many times to even have to discuss this, much less, sort of go through the process of reviewing the form that the tax practitioners put together for her. IRS will not take any collection action against the survivor while a request for relief is pending. It usually takes 6 months, and it can take 9 months or a year for IRS to make a decision. And I strongly recommend, if you have a taxpayer who looks like they might be a good candidate for innocent spouse relief, helping that survivor, that client, find a tax professional to represent her. It's really complicated. I've added a slide here that lists some of the places you can go to get more information about innocent spouse relief. All of these are available on the IRS website. You may have a client who is facing IRS collection. IRS has all kinds of tools to collect tax, but it also offers a range of collection alternatives to make life easier for the person who owes the tax, including settling tax debts through the Offer and Compromise program, which is a great program to help a client who is facing collection. We've settled tax debts in the hundreds of thousands of dollars for, $20, $50, and really small amounts. Finally, there are some slides on IRS, actually not finally because there's a few things after this, but on IRS disclosure rules. Tax return information is kept confidential from anyone who did not sign the tax return. But on this slide here, there are a list of exceptions. So, for example, if a taxpayer comes to me and signs the requisite form to disclose information to me, I can see the information that's on that tax return. Similarly, there are there are a range of organizations, law enforcement, state tax departments that also by statute have access to tax return information. If you want your client to release tax information to you, they're going to have to do it on one of the IRS forms, this one's got a typographical error in it. It's not a 2484, it's a 2848. Sorry about that, which actually appoints, if a taxpayer signs that, it authorizes the people listed on the 2848 to be the taxpayer's representative before IRS, unlike the 8821, which just authorizes information to be gotten. When it comes to requesting innocent spouse relief, by law, IRS must contact the non-requesting spouse, maybe the abuser, and allow that person to participate in the process. The IRS does keep certain information private, the location of the requesting spouse, workplace, income, that kind of thing, but the allegations that are contained in the request for innocent spouse relief are made available, and the non-requesting spouse has the opportunity to respond. Let's see. One last thing, as far as a practice tip is concerned, the IRS is a great source of information about your client's tax situation, and your client, or you acting on your client's behalf, can get account transcripts that show for each year all of the, whether tax returns were filed, whether there was an audit, whether there were refunds, whether there's a liability, what payments were made. Wage and income transcripts are available about your clients to show how much income was issued to your client, and there are tax return transcripts and copies of tax returns that can be requested from IRS. Finally, there is free tax help available. There is at least one low-income taxpayer clinic in every state, and so and they provide free legal representation to low-income taxpayers who have federal tax problems, everything from audits to innocent spouse relief. There's also the Taxpayer Advocate Service, and I encourage you to go on their website. There's one in every state, and there are some states like Ohio that have multiple Taxpayer Advocate Service offices. They are there to help taxpayers resolve IRS tax problems. There are places where one can go to get free tax preparation service and a search tool on the IRS website to locate the closest free tax preparation. And there is also Free File on the IRS website, which one can use to e-file one's own return using free software, so long as your income is below $62,000 for 2015. We've gone over. So no, I'm now going to turn it back to Sarah and/or Erica.
Thank you so much, Jamie, and thank you everyone for hanging with us. This is a lot, but important to really provide the survey of what's going on here. And before we lose more of you, I do want to ask this final question. We know, take a look in the right-hand side of your toolbar. You should see an open poll. What do you need to see more on? We know that we tried to cover a little bit of everything. We also know from your registration surveys and your questions that there are a lot of specific issues that you'd like us to dive deeper into. And so we'd like to get a little bit of your feedback before we lose too many of you. And again, once you, we invite you to leave if you need to go. Thank you very much for being so generous with your time. We're just going to go over some announcements that we feel are important to give you all as we move forward to see what's up next, but we'll make sure to get that to you in some follow-up emails. So just as a quick little, very non-scientific survey, I'm going to close this for now to show everybody what we're doing. It looks like a lot of folks, I hope, have chatted us some of their options, and we've also got a fairly even split between going more into rights and obligations as well as deeper into innocent spouse relief. So we're really going to take some of your feedback, and we're going to take your feedback from the survey as well as from here and try to follow up with you on all of that. So thank you for doing that. Again, here's Jamie's contact information. However, we'll be sending you some follow-up email, also posting the materials so that we can capture some of the frequently asked questions. We do urge you to contact us, and we'll provide that information at the end here so we can kind of help channel some of the common thoughts and questions and challenges that are going on. And again, just as some resources and announcements for you, we have a whole lots of information on our website in our resource library. Here are a couple related to tax. If you want to know, if you work with survivors in the context of the military, we have a webinar. We have a more in-depth resource by Barbara Hart, who I believe was joining us today. Thank you for being here. And Jamie is also helping us work on another advocacy brief regarding taxes. So we will take everything that's gone on today into consideration as we do that. So be sure to look out for that as it comes. In addition, Erica mentioned this at the beginning, but one thing we didn't really talk about is that Jamie is the leader of one of our innovative demonstration sites. She does really deep and rich work with the low-income taxpayer clinic there in Indiana. Her work has been featured so far with us in our innovative pilot site report on how she went through the process of building partners, not only amongst attorneys and tax practitioners, but within the DB advocacy communities there in Indiana. An amazing, very thoughtful and context-specific look at how to make connections between your work and the expert and technical resources that survivors are needing in your community. In addition, we also work closely with the Domestic Violence and Economic Justice Task Force here in New York City. It's another innovative model, task force model that provides that prioritizes local needs here in the city as well as develops tools in a collaborative effort. So there's some contact information about and some different resources coming out of that that's helpful not only in how you might be able to organize in your communities, but also what some ways, what can come out of that. In addition, some of this you've seen before. Please go to our resource library, check out some of our core resources on how to do broad-based survivor-centered economic advocacy, whether you're an individual practitioner or you are a director of an organization, or if you're not directly, if you're a tax expert or not directly, don't feel like you're directly dealing with survivors directly, you likely are, and there's a lot of insight that we can help you work around. So please call us and let us know what you're seeing and what you're doing, and we'd love to connect with you and strategize with you moving forward. And we mentioned some of the advocacy briefs, so they're also available on our resource library, including the new one reviewing the recent credit settlement. So we encourage you to check out everything there and let us know what else you might need in your work going forward. And last but not least, in terms of announcement, we have a lot more consumer practice webinars coming up at the end of March and the end of April. So please check our calendar and sign up for our mailing list so you can get notices of all of that and participate and get all of those resources as they come down the pike. We're really excited for the calendar that we've been able to put together. And we have a really big final announcement, so I'm going to turn it back over to Erica to close us out.
Wonderful. Thanks so much, Sarah. So I'm thrilled to be able to share with all of you a new and I think groundbreaking project that the Center for Survivor Agency and Justice is launching. And that is a project called the Legal Impact for Racial and Economic Equity of Survivors, otherwise known as REAP. And this project really is focused upon trying to remedy the systemic inequalities facing survivors of color that impair their access to economic justice. So it's taking a careful look at communities and organizations and trying to identify, both through data collection and through the experiences accounted through survivors and advocates, that, that are systemic barriers to economic opportunity. We'll be working in coalition with diverse anti-poverty, race equity, and violence against women practitioners. And we'll be engaging communities in identifying these barriers and then implementing legal and policy approaches that are tailored to facilitate access to economic opportunity. Some of our key partners in this work include the Women of Color Network, the Southwest Center for Law and Policy, the Asian Pacific Islander Institute on Gender-Based Violence, Casa de Esperanza, NLADA, Legal Momentum, Bill Kennedy of the Race Equity Project out in California, as well as the Kerwin Institute. So this is a really nice opportunity to do some of this systems change work, particularly targeting barriers facing survivors of color. And we really encourage you to get in touch with us to learn more about the project and to share with us what's happening in your own communities and states. With that, I just want to say huge thank you to Jamie for leading us in today's conversation and sharing all of your really nuanced and rich expertise with us. And thanks everybody for participating in today's call with your questions and experiences. Have no doubt that we will take all of the information that you've shared with us and we will provide some very detailed follow-up to you. Many people have asked about access to the PowerPoint. You will absolutely be getting that, as well as many other resources that have been referenced throughout today's webinar. So all of that is forthcoming. And the webinar itself will be posted on our website by this coming Friday. There's a link that Sarah just shared with all of you. Thanks so much for joining us today. Looking forward to continuing to learn from you and with you in the future. Take care.